Hotel liability for guest property from common law through today. The history of the inn. The common law liability of the innkeeper has remained constant throughout its history. 3 rules remain the same. 1. Liability from the innkeeper is a prima facie for goods they are to take care of, but the hotel is allowed to show proof through no fault of their own that the goods were not lost or stolen through negligence on their part. 2. Acts of God are not covered by the hotel. And 3. Acts of God, public enemy, and the fault of the patron themselves. The innkeeper is only liable if they do not use the proper channels to prevent negligence in such circumstances. Common law would originally dictate the innkeepers were liable for all forms of property that came across their threshold. There are no limitations. The innkeeper was only liable for the goods if the patron was indeed a guest at the inn. If lost or stolen items happened before or after the patron was considered a guest, they would not recover. If the valuables arrived before the guest, the innkeeper was only liable as a gratuitous bailee and not the insurer. The innkeeper was only responsible for ordinary diligence if they were being paid to watch the goods. If not paid, they were only responsible for a slight diligence. Acts of God are covered by the limitations for innkeepers, but fire is only covered if it was started by lightning or another natural, not man-made cause. If the fire started as an accident due to negligence, then the innkeeper would be liable for all goods damaged or lost due to the fire. The innkeeper had a duty to accept all patrons who seemed sound to their premises, because the roads were not safe at this time. It is a duty required by law that all guests are allowed to stay at the inn during the common law. The innkeeper is liable for all staff, guests, and property. There is some belief the innkeeper is able to control all guests and staff on the premises. The innkeeper reserved the right to refuse service to ill-reputable persons. The innkeeper must show reasonable care to the guest for safety, comfort, and entertainment. Reasonable care must also be taken to protect the guest from injury by other guests, staff, or natural disasters. If the guest wanders into a place they should reasonably not be on the premises, the innkeeper no longer becomes liable for their safety. The innkeeper owes the guest a sanitary room, decent food if offered, and privacy. The start of the common law in England around the 13th through 15th centuries. Common law started out as a binding rule but not used as a legal precedent until used in the court of law. Modifications of the common law started as the origin of judicial law. Common law uses a form of reasoning with analogy. This is done by taking other cases that are similar in reasoning and trying to twist it to be like the cases judges are currently working on. English common law started after the Norman conquest in 1066. All the way up until the late 19th century, common law was mostly made by judges and not legislatures. Common law started out as procedural remedies. Local customs took precedence, as did the church. Crimes were wrong and required compensation to the victims. The unwritten common law, the government came centralized with bureaucracy and written records. During Henry II's reign, from 1154 to 89, officials were going around and asking how justice was administered. Church and state were separate. Land ownership was a common form of wealth. Inheritance indeed started before common law and were adjusted by the king's court. These remedies were the start of the common law in the 12th century. The 13th century started with statutes to help streamline important matters. Judges were in charge. Royal judges started traveling around to local towns to try civil and criminal cases. Both local customs became ignored in favor of the ruling of the judges. Writs or written words started around this time too. In 1275, the Statute of Westminster made the jury trials obligatory in criminal cases, clauses that were to help the common people. In 1278, limited jurisdiction. The Statute of Gloucester allowed the common person to recover damages and the cost of the lawsuit. The Statute of 1290, also known as the Third Statute of Westminster, this basically helped settle the estates. This also brought ownership of land to be more in line with lords rather than passing around law on someone other than lords to have ownership. Law of equity is as old as the common law but not needed until the 14th century, was formed to prevent injustices in the law. This was made because the law had up until this point been fluid, and with the law becoming more established, it required more evidence and sealed contracts. Informal or secret contracts were made invalid. Lord Chancellor becomes the Court of Chancery in 1372 to 99. They modified the rules by working out the kinks in the system. They were allowed to modify rules of common law and deny or approve decisions without reason. Bills, subpoenas, fraud, breach of confidence, unjust retention of property were all started during this time. Written pleadings started at this time too. Edward I's reign brought in the judge as a full-time position, and the bar was established. The clerical position was turned into a judge. Legal education for the bar was required at this time to show more knowledge of the law. At this time, the education looked like attending court proceedings, simulation of disputes, and lectures by more experienced lawyers. By 1280, there were multiple uses of notes from other lawyers who attended different cases. These varied in accuracy depending on note takers and how often they showed up to the courts. These turned into the yearbooks. These are used in most court cases to see how to proceed with similar situations as they developed. The 15th century brought about more order in the law. The written process became more popular as the oral process moved out of the way. The more outlying provinces did not take well to the king's orders, overtaking their local customs. The 16th century English common law became case law. Improvements to the written law versus the oral. The yearbooks became the basis for case law. This law movement more from oral to written law. English law focused more on practical versus abstract law. Continental law brought about some rules and contracts, and Roman law helped form the Act of Negligence. In 1600 to 1650, Edward Coke brought about the first written court cases that set the precedent for many court cases. Edward Coke was a barrister and a judge. He formed the only collection of law cases for his time. He supplied the court with a copy of his records for each case. He was an open advocate of common law. The late 16 and early 1700s saw the colonies start their own statutes because England law was slow to arrive. The inns were mostly just places to rest and get some food. The innkeepers would take care of the horses, which was the main mode of transportation at the time. In 1765 and 1769, Sir William Blackstone wrote the Commentaries on the Laws of England. He took the bar in 1746 and became the first person to lecture on English law at the English University, according to Britannica. 1776, the Commentaries were the chief source of law in the New World. The settlers did come with habeas corpus and a right to trial by jury. Common law was adopted by each colony with their own variations. Governors and legislative bodies acted as the courts. Late 1700s brought about practice lawyers. Many were fought on common law principles, and over half the signatures on the Declaration of Independence were lawyers. 1830 was James Kent and Joseph Story made commentaries on common law and equity. They put emphasis on the security of title property with legal definitions. This was widely accepted in the U.S., with the exception being Louisiana, which has since followed French common law. Around the American Revolution, a lot of English laws went out the window. Americans wanted more cementing of the law with the founding of the new continent. The pioneers preferred experience and experimentation over outdated decisions. They did not like the central government. Church courts were no longer allowed, and inheritance was for everyone, not just the firstborn son. The 18th and 19th centuries saw several legislation ideas that were not popularly accepted among the states. The U.S. common law is not as near as English laws, and with much less reluctance to change laws. The 19th century brought more all-inclusive atmosphere to inns and more luxury. This brought about the hotels. 1950 saw room service and TVs in bedrooms. The probate in the 18th century American law has become a matter for the lower courts. In 1803, the Supreme Court became the ultimate authority. According to Britannica, most federal law is statutory and enforced by federal courts. Law concerning labor, security, shipping, interstate commerce, antitrust regulations, patents, and copyrights fall into this category. Following the decision in Marbury v. Madison in 1803, an act of Congress was declared unconstitutional and established judicial review. The Supreme Court became the ultimate authority for determining the conformity of all legislation with the federal Constitution, which guarantees many fundamental rights. In 1930s, we saw the introduction of interstate commerce, which has been upheld by the Supreme Court, which also saw minimum wage and collective bargaining appear as well. In 1950, the human rights started the movement to help with to move into the 1964 Civil Rights Act. The act was made by Congress to pass laws against discrimination based on race, color, religion, or national origin. This only applies to the 4 areas of lodging, dining, places of entertainment, and gas stations. The Discrimination Act was to help with people in these classes being denied equal treatment as everyone else. In order for these businesses to not only fall under the Civil Rights Act, they must also be part of interstate commerce. This means these businesses must be dealing with 2 or more states. If no business is dealing with 2 or more, they states are considered local, and they are regulated by state or local laws versus the federal laws. In 1973, the English system integrated into the European Union. The United Kingdom exited the European Union in 2020. Under common law, the innkeeper was responsible for everything a guest brought with them for their stay. Today, that law has changed to statutes in the U.S. that vary by state, allowing the hotels that are responsible or not. The liability today only starts when the guest and luggage are together at the hotel, unless stated otherwise in the contracts. At common law, the responsibility on the innkeeper started as soon as the goods arrived at the inn. The common law only applies to civil cases. When the common law was adopted by the states after the American Revolution, if the state was a territory beforehand, then which law overtook the other was judicially decided. English law versus American law. English law states that hotels are liable for irresistible forces or an inevitable accident. This is adopted in Minnesota and Vermont. In America, some states use the act of God, natural disasters, public enemy, or the fault of the guest as a reason to not be liable for destruction of property. This is only possible, as in common law, if the innkeeper did not take proper action to ward against negligence in these cases. Most states have a statute stating, unless money, jewelry, etc. is placed in the care of the innkeeper, that the innkeeper is not liable for any loss, stolen, or destruction of property. According to Britannica, the most striking differences are found in the area of public law. England has no written constitution and restricts judicial review, whereas every court in the United States possesses the power to pass judgment on the conformity of legislation and on other official actions to constitutional norms. The responsibilities of the hotels for guest property. Today, innkeepers must accept all who request to be a guest. They do hold the right to refuse guests who may be objectionable. Illegal acts by the guest does not absolve the innkeeper of the liability of lost or stolen items unless the acts of the guest have necessitated it to be so. An innkeeper is required to be liable to the guest as far as luggage is concerned. This includes money, cars, and contents of the cars. The responsibility starts as soon as the goods are delivered. The property is a liability of the innkeeper while in transport at the request of the guest. Baggage, car keys, and goods must be handed to an employee of the inn or for the liability to kick in. In order for liability to kick in and not revert to common law, there must be notices posted to inform the guest on the limitations of the liability the hotel provides. At common law, and even today, hotels or innkeepers may keep luggage or other valuables as a lien for services rendered. This is found to be valid in the U.S. under constitutional law. Today, still allows an innkeeper or hotel to refuse service to unlawful people. This does not, though, give them the right to discriminate based on race, religion, ethnicity, or others protected by law. A guest may be asked to leave for acting disorderly, refusing to pay a bill, becoming rude to other guests, and just causing problems overall. Today's hotels must find reasonable accommodations for guests if the hotel is overbooked or does not honor an agreement to the guest with a reservation. Non-guests or people who have no intention of being a guest are only allowed on the property with permission from the hotel. These people may be asked to leave if they violate any of the rights of the guest, become disorderly, or just cause issues. Most statutes have put a limit on what hotels are liable for. Things that will be sold like silverware, large collections of coins, gems, etc. will not be covered under a liability statute. And Airbnbs, since becoming more popular, have come under scrutiny. They were found in 2005 to be discriminating against names that sounded black or had a profile of someone who was not white. Policies have since been put in place telling hosts that they may not discriminate based on race, color, ethnicity, national origin, religion, sexual orientation, gender identity, or marital status. The only exception is if the hosts were to share their personal space with the guests, then they may limit the listing to only the same gender as the host. The end.